Good evening, everyone.
Good evening.
Okay, so tonight we're doing module 5, correct?
Yes.
Okay, good. Just making sure. All right, anyone had a chance to read it through? Hello? No?
No.
Not completely.
A little.
A little, okay, all right. So let's start with history of the courts. I mean, everyone should have an idea of how we started. Hold on one sec for me. So we know we are a chain of islands, and we know in 1492, Christopher Columbus landed here. And the British started coming here in 1647, and we became a British colony in 1783. After that, we got our independence in 1973 on the 10th of July. And of course, we are a parliamentary democracy, a constitutional one. And we have 3 branches of government, namely the executive, the legislative, and the judicial branch. The head of our executive branch is the Queen, and she is represented locally by the Governor General. And the Supreme Court and the Court of Appeals are enshrined in our Constitution under Articles 93(1) and Articles 98(1). So our legal system, of course, is based on English common law. And over the years, our courts have evolved from the British system to the current structure that we have now. So our lowest court is the Magistrate Court. That is our primary court for many civil and criminal cases. The magistrates are appointed by the Governor General upon advice of the Judicial and Legal Service Commission. The court is presided over by the stipendary and the circuit magistrates, and that includes the chief magistrate and 2 deputy chief magistrates. So together we have 17 magistrate courts in the Bahamas, 14 in New Providence, 2 in Freeport, 1 in 8 Mile Rock. And of course, for a magistrate, they must have been called to the bar and be a member of the English, the Irish, Scottish, or Bahamian bar, and should have practiced for at least 5 years. So after the Magistrate Court, we have the Supreme Court. And the Supreme Court itself is a judicial system. It operated since the 9th of August, 1897. The several courts prior to the 1896 Act were united, and they were consolidated into one Supreme Court, hence the constitution of the new Supreme Court of the Bahamas. That was repealed and replaced in 1996. And of course, it can be found in the statute laws of the Bahamas. Appeals from the Supreme Court are sent to the Court of Appeal and to Her Majesty's Judicial Committee of the Privy Council. The Privy Council is the highest court of appeal for United Kingdom for overseas territories and crown dependencies, and also for those independent Commonwealth countries like the Bahamas, who have retained this process to the United Kingdom. So there are 12 justices appointed to the bench of the Supreme Court, inclusive of the Chief Justice. And the Supreme Court has unlimited jurisdiction in general civil and criminal matters. There are 2 judges assigned to Freeport, and matters from the northern region, which includes Bimini, Abaco, and Grand Bahama, are heard there, unless, of course, the matters are transferred to New Providence for some good reason. The Court of Appeal is the highest court that is resident in the Bahamas. It is part of the judicial branch of the government, and it was established under Article 98. The Court of Appeal sits on a full-time basis throughout the year. It has jurisdiction in criminal, constitutional, and civil matters, and it includes appeals from the Industrial Relations Tribunal under the Constitution and under the Court of Appeal Act and other statutes. So it enforces fundamental rights and freedom under the Constitution. Under Section 11 of the Court of Appeal Act, from any judgment or order given or made in civil proceedings, from persons convicted on information of the Supreme Court, from the Industrial Tribunal, from courts martial under the Defense Act, from offenses under the Proceeds of Crime Act, from the Disciplinary Tribunal of the Bar Council, and from the Medical Council and Disciplinary Committee of the Medical Council. So the court also has jurisdiction to hear appeals from interlocutory decisions in civil cases in the Supreme Court, usually with the leave of the trial judge. So the registrar is the civil service administrative head of department for the purposes of the Judicial and Legal Service Commission regulations, as well as the Public Service Commission regulations, and the accounting officer for the purposes of the Financial Administration and Audit Act. The registrar also has judicial functions. Any correspondence intended to reach the justices of appeal or an individual justice of appeal is required to be addressed to the registrar. So the Court of Appeal is comprised of a president, a chief justice ex officio, who sits only at the invitation of the president, and such number of other justices as may be prescribed by Parliament. So presently we have 3 resident justices of appeal and 1 non-resident justice of appeal. Note that the retirement age of 70 and also for any such period after attaining that age as may be necessary to enable them to deliver judgment. You'd see from the chart that I have in the handout, you have Honorable Sir Michael Barnett, and then you have the Justices of Appeal, and you have a registrar, and of course, the clerks. The Privy Council is established under Article 105 of the Constitution. The first historical visit of the Privy Council sitting was in 2006. And the visit was followed by a seating in 2007 and 2009. The Privy Council held their 4th sitting in 2017. So if you look, you would see the judicature of the Bahamas. It starts with the Privy Council, the highest court, then the Court of Appeal, Supreme Court, Magistrate Court, and the Family Island administrators. Any questions? None? So after briefly looking at our judicial system and the structure of our legal framework here in the Bahamas, we now move more into businesses as we go into this whole area of investments and assets. So the first thing when you're doing business is you have to consider, what type of business do I want to go into? What kind of structure do I want? And before you even apply for a business license, you have to consider, what's the best option for me to conduct my business? You have to think about statutory reporting. You have to think about filing requirements. You have to think about annual licensing, contractual agreements, internal controls and operations, the interrelationship between the principals of the company, the officers, and you have to think about accounting and financial records. And all of those help you determine what type of structure that you're looking for. So normally you have to decide between a sole proprietorship or whether you should form a partnership or whether you should form a company. And each one has its advantages and disadvantages. So a sole proprietorship is owned by one individual. That person has sole control and responsibility and liability for the business. Now, a lot of people use this structure because they realize that all of the assets are theirs. They make all of the decision, all the profits are theirs. And of course, all the liability is theirs also. So the legal and financial liabilities related to a sole proprietorship extend directly to the owner and that owner's personal assets. They're not just limited to the business. The legal liabilities of a sole proprietorship are unlimited. And creditors or any litigants can claim and enforce their judgment against that sole proprietor and all of their personal assets. So this is one of the main disadvantages of being a sole proprietor. Now, of course, a sole proprietorship is easy to start up because it just requires you to register your business name. And of course, you go to the Department of Inland Revenue and put in your application. And you have a company established. But the issue with this is that one of the difficulties you have with this is that once that proprietor dies, the business dies. Now, let's look at a partnership. A partnership is a non-corporate entity with two or more owners, and they're normally governed by a partnership agreement. So normally partnerships take the form of entities that we call firms. They are similar to a proprietorship, a sole proprietorship, in that the legal and the financial liabilities of the partnership extend beyond the partnership to the individual partners and their personal assets. So a creditor can sue partners individually to satisfy their obligations of the partnership. Partners are also liable for the actions of the other partners, where such actions were done on behalf of the partnership or in the partnership name. Of course, there can be exceptions. It's strongly recommended that prospective partners utilize the services of an attorney to draft and vet a written partnership agreement, where you would address all of your specific areas of the operation and management of the partnership and relationship. You talk about the rights, the duties, and the obligation. So all of those provisions are put within the partnership agreement. Of course, original partnership agreement automatically terminates on the death, the resignation, or the addition of a new partner. Issues relating to expansion, dissolution, and buyout arrangements should be agreed and specifically discussed before the occurrence of such events. And you do this so that you minimize problems and challenges that could come in the course of the partnership. So a partnership can be a general partnership, and that's where each partner has unlimited liability, or you could have a partner, maybe a limited partner, where their involvement may be limited purely to financial matters. The limited partner also doesn't participate in any decision-making in the partnership, where his liability is limited to the amount of the money that he invests in the business. So that's sole proprietorship, and that's partnership. Your third option is you can incorporate a company. When you incorporate a company, that company is considered a legal entity, separate and apart from its principals or shareholders or members. The liability of the company is limited to what the shareholders have invested in the company. So when you sue the company, if you want to sue the shareholders, it's limited to the amount that they have invested. So a company in the Bahamas can be established either under the Companies Act of the Bahamas or under the International Business Companies Act. And of course, there is a process where you reserve the name and then you file a memo and arts. And then once you meet those requirements, then there's an issuance of a certificate of incorporation. So a company becomes a separate legal entity when it receives its certificate of incorporation. So of course, the incorporation of a company is more costly and requires more paperwork than a sole proprietorship or a partnership. A company requires annual license fees, filing of statutory documents, and of course, maintenance of documents. So you have to have good record keeping. Under a sole proprietorship or partnership, a company survives the death of a shareholder, of the shareholders. Whereas when a sole proprietor dies, the company dies. Partnership, if one of the partners dies, then of course, the partnership is dissolved, unless there's some other provision made in the partnership agreement. A company can issue shares. It can raise money on the international market. It can add directors. It can remove directors. It can add shareholders. It can remove shareholders. The company can expand. It can downsize. All of these things are subject to the memo and articles of the company. And all of these changes can take place without changing the legal existence or the structure of a company. So whenever you're going into business, you have to think about the advantages and the disadvantages of a sole proprietorship, a partnership, and a company. And you have to look at the reporting requirements and what makes sense based on the business that you're entering into. Any comments?
One question, I have a
Go ahead.
question. Does a partnership agreement or bylaws supersede like the company laws? Like if you have a dispute in the partnership,
Mhm.
but you agreed to certain things in the partnership agreement, but the laws, because we have company laws as well that we have to abide by, which would supersede what?
Now, I don't know, I understand what you mean when you say you have company laws. What do you mean, company laws for what?
No, we have company laws in the Bahamas, right? Laws that companies should abide by. The laws.
Yeah, no, but that's, okay, so the company's law, the company's law only applies to a company.
Okay, okay.
Right.
So that wouldn't come in partnerships or
No,
anything.
no,
All right, okay, I got
No,
you. Thank
right.
you.
So if you incorporate a company under the Companies Act, then you abide by the Companies Act. If you incorporate a company under the IBC, then you follow the IBC Act.
Okay, let me see if I
Right.
follow you. Yes,
Okay.
okay. So I incorporated a company. That's when you get your articles of association and your memorandums and everything. Is that the same thing?
Yes. But
Okay.
what I'm saying to you is that when you incorporate a company, you have two pieces of legislation to choose from which one you want your company incorporated under, because there are different requirements.
Right.
So you could, let's say you want to incorporate a company. You could incorporate it under the Companies Act, which has more regulatory requirements and statutory filing requirements versus an IBC, which is simpler.
Right.
A
And if you
partnership is totally different.
Okay, so if you have these things, if you incorporate under whichever one of those laws, and you still have an agreement, say, with your shareholders and stuff, there's still the law of the land would still supersede any agreement that you and your shareholders would have. It's basically what I'm
Yes.
saying.
Yes,
Okay, all right.
right. So when you
Thank-
form a company, when you create that company, the shareholders can come together and draft a shareholder agreement. And that shareholder agreement contains all of the issues in the event that something happens. This is what we are going to do. That's what that is about. It's like a reference document to go to. Let's say the company only has 2 shareholders. So the shareholder agreement would say, in the event there's a disagreement between Mr. A and Mr. B, first there will be mediation, and that will continue for 20 days or 30 days, and then it'll say, and if the dispute is not resolved, we move into arbitration. They may also discuss as to who has preference to buy the other person's shares, or whether or not the shares will be sent out for a family member to purchase. So all of those small little disputes that can happen are part of the shareholders agreement.
Okay, thank you.
Okay. Any other questions?
Yes, I have a question.
Go ahead.
I think you mentioned if somebody is suing a company, does that mean the shareholders are being sued or the company?
The company itself. But if you want to go behind the shareholders, their exposure is only limited to what they have invested in the company.
Okay,
The only way you can go behind the company and sue the shareholders is if you are able to demonstrate to the court that the whole, whatever the transaction was, or the whole incorporation of the company was fraudulent, that you're trying to deceive someone or defraud someone.
okay.
Yeah.
I have a question. You said if you incorporate a company under the Companies Act, is more restrictive than the IBC law. So why would you choose the first option?
Well, it depends on the type of business that you're going into. If you're going into a large business like Commonwealth Brewery, like a bank, like a trust company, an automobile company, you would choose a structure like a Companies Act company. So you have to meet the requirements of annual filings versus an IBC. An IBC has a simpler format in terms of maintenance of that company, and the requirements are different. So that's the IBC is what a lot of our international clients use, because it requires just one shareholder, one director, which can be the same person. That director can also be the officer on the company. And there's less filings at the Registrar General. Instead, you make declarations.
Okay.
Yeah. All right, so let's talk about seeking residency in the Bahamas. So we know that seeking residency means you going to immigration. And we know that foreigners normally apply for permanent residency. So any non-Bahamian who wants to live and work in the Bahamas must seek authorization from the Department of Immigration. And this comes in the form of a residence permit. Permanent residence is a status issued to an individual for the duration of his or her life unless revoked. And it gives him or her the right to live and or work, but not the right to vote in the Bahamas. Now, to be eligible for permanent residency, you have to be either the spouse of a Bahamian after 5 years of marriage. The marriage is still subsisting, and the couple cohabitating as husband and wife. or the persons are born legitimately outside of the Bahamas to a married woman who is a citizen of the Bahamas and whose husband is not a citizen of the Bahamas. Or it could be a financially independent individual or investor with who are legitimate owners of residence in the Bahamas, and they're purchasing a residence of 1.5 million or more. They will get a speedy consideration. Prison and police officers employed in the government service for minimum of 10 years. Teachers employed in the government service or by charitable or religious institution for a minimum of 10 years. Nurses employed in the government service or with the private hospitals and healthcare facilities for a minimum of 10 years. A minister of religion or priest having been employed for a minimum of 20 years. A doctor or medical professional employed for a minimum of 20 years. A Haitian national who are able to provide documentary proof exclusive of Haitian passport that the department accepts as evidence under cover of an affidavit from a notary public of their continuous residence in the Bahamas prior to January 1985. And persons who have held legal status, that is a work or resident permit, for more than 20 consecutive years. Now you can also apply, foreigners can also apply for an annual residence permit. And that's for persons who reside in the Bahamas on an annual basis. And they can qualify for any one of the 4 categories: spouse or dependent of a citizen of the Bahamas, if married to a Bahamian citizen, a spouse or dependent of a permit holder, an independent economic resident, or a resident homeowner. And resident homeowners are non-Bahamians who own second homes in the Bahamas. They can apply to immigration for an annual homeowner's residence card. The card is renewable annually and entitles the owner, spouse, and any minor child or children endorsed on the card when traveling with the owner to enter and remain in the Bahamas for the validity of the card. The visit is for a stay up to 1 year. Of course, you know, the Department of Immigration also issues work permits. And the government has a principle that no expat may be offered a position that a suitably qualified Bahamian is available to fill. So if there is no suitably qualified Bahamian, then an application is submitted to the Department of Immigration for permission to recruit outside the Bahamas. Note that the application will not be processed if prospective employee is already in the Bahamas, having entered as a visitor. So where work permits are being granted, each employer is required to identify a suitable Bahamian to understand the expat's position within a reasonable time frame. The employer also can obtain permits for longer periods than the standard 1 year in certain key positions or contracts. A person holding a work permit may make application for a new one without having to leave the island. And that happens when the new employer, his new employer, having been unsuccessful in recruiting a qualified Bahamian to fill the post. Renewal is not automatic. And no expat may continually be employed in any capacity for more than 5 years. So any non-Bahamian national who is desirous of working and living in the Bahamas for a period greater than 90 days must first be authorized to do so by a valid work permit issued by the Department of Immigration. And if you wish to work for up to 90 days, you must apply for a short-term work permit or visa. So any foreigner who is married to a Bahamian may be eligible for a resident spouse permit. And the permit allows the spouses of Bahamians to legally live and work in the Bahamas, provided that they live with their Bahamian spouse, not being married for less than 5 years at the time of the application. Once 5 years of marriage have passed, the non-Bahamian spouse may apply for extension of resident spouse permit citizenship or permanent residency. So I mentioned earlier that a foreign national can obtain residency in the Bahamas through investments. So under the national investment policy, the minimum investment for purchase of a residential home is 1.5 million. In order to meet the requirements for accelerated consideration of permanent residence in the Bahamas. Of course, the individual has to be fit and proper, and that due diligence is done by the immigration authorities. Note that a prospective resident will have to meet the other immigration requirements for permanent residency as well. So you have to be of good character and you have to show evidence of financial support. The applicant must also state that he intends to reside in the Bahamas permanently. So the application for permanent residency would be made under the category of economic applicant. That is, one who seeks permanent residency because of investment in a residential home in the Bahamas. Of particular importance is the fact that a person holding a certificate of permanent residence who wishes to include his spouse or dependent child under the age of 18 can do so by having his spouse or dependent child endorsed on the certificate. So why would a foreign national want to apply for permanent residency? First, it gives them the right to reside in the Bahamas without further renewal of permits. It makes them eligible to apply for citizenship of the Bahamas after fulfilling residency requirements. Except for the right to vote, they enjoy the same privileges as a Bahamian. Of course, you know, the Bahamas have liberal tax regime. It also gives them the right to purchase property in the Bahamas. And of course, it's easy for them to travel because then they become a member of the Caribbean community, members of the OAS, and of course, members of the Commonwealth of Countries. So a permit to purchase or acquire property is required by all non-Bahamians if the property is undeveloped land and the purchaser. A permit is also required by a non-Bahamian who intends to acquire an interest in land in 2 or more adjoining acres. Bahamians are also required to apply for a permit where the intended use is not as an owner-occupied property. So under the International Persons Landholding Act, a non-Bahamian or permanent resident who purchases or acquires an interest in a condominium or vacant property or otherwise to be used by him as a single family dwelling or for construction of a dwelling must apply to the Bahamas Investment Authority to register the purchase. So persons who are eligible include non-Bahamians acquiring that interest in land or condominium, permanent residents of the Bahamas, any non-Bahamian acquiring an interest in land under a device by inheritance, non-Bahamians acquiring an interest in land by a court order or as a mortgagee, or a non-Bahamian acquiring a leasehold interest for trade or business for a period greater than 21 years. So any Bahamian who owns property on any of the islands is eligible to apply for a homeowner's card. And they do so by writing a letter to the Department of Immigration and of course, providing supporting documents. Stamp tax on real estate transactions. There's a 2.5% government stamp duty is charged on all real estate transactions valued over 100,000, and a total tax of 10% on all real estate transactions valued at 100,000 and over. So unless otherwise agreed, it is usually that stamp duty is split 50-50 between buyer and seller. So under the real property tax rates, the first 250,000 on owner-occupied residential property is tax exempt. The next 250 is at 0.625%, and over 500,000, the tax rate is 1% of the remaining value part of the value. Residential properties that has 4 units or less and is used solely as a dwelling place, the first 75,000 of property value is a flat fee of $300. Anything above the first 75 is 0.625% of the remaining property value. Commercial properties above 4 units, even if used as a dwelling place, the first 500,000 property value is 0.75% of the property value, and anything over 500,000 is 2% of the remaining property value. Vacant land for foreigners, the first 7,000 of property value is a flat $100, and anything above that 7,000 is at a rate of 1.5% of the remaining property value. Of course, you know, there are exemptions. Property owned by Bahamians and situated in the Family Islands is exempt from a real property tax. However, property approved as commercial farmland by the Ministry of Agriculture, Trade and Industry is eligible for property tax exemptions. Only foreigners pay on the Family Islands. Also exempt from real property tax is unimproved property owned by Bahamians and property used exclusively for charitable or public service for which no profit is derived. Properties located in Freeport that are still under the Hawksbill Creek Agreement, and all buildings that are registered on the National Register of Historical Buildings are eligible for exemption for real property tax. As you all know, because the government has made a lot of effort in trying to collect real property tax, you know that it is paid to the Department of Inland Revenue, and no VAT is added to real property tax because it is already a tax. And senior citizens have a benefit from real property tax. After the 250,000 exemption, there's a 50% discount on the balance of home value not exceeding 1 million, but the person must be 65 years of age and have an NIB senior citizens card. And of course, if full payment is made by the March 31st of any tax year, they also get another 10% discount. And you know, for all real estate services, including appraisals and legal work and commission, you know that you have to pay a VAT of 10%.
Question for you.
Go ahead.
Had a discussion previously. What is the reasoning why real property tax is assessed?
What you mean?
Why
Why we have to pay it?
citizens paying? Yeah.
It's a form of generating income to pay for the government to pay its bills.
Bills, right? So there's, I
Yeah.
mean, there's no real reason, it sounds like, for a tax on a property that you supposedly own.
Well, you know, now hold on now. Hold on. Hold on. Let me explain this to you. The land that you have your home on, whether you paid mortgage or you paid off your mortgage or you paid for it cash, in law, you only own an interest in that land by law. You have an interest in that land. The land is owned by the Crown.
So it's like a lease then. So you're telling me you're leasing?
No,
the
it's not a
land?
lease, not a lease. No, it's not a lease. A lease is where a person has what we call a fee simple absolute in possession, which means that they own both interests in the land. They own the legal interest and the equitable interest in the land. And then they decide that, guess what? Because I have both interests in this land, there's no claim against this land, I don't owe anybody. They then decide that, guess what? I would let Mr. A farm on my land or use a building that's on my land for whatever reason for 60 years or 80 years. That's a lease.
Mm-hmm.
And that
I guess
person
I set up because you don't outright own it, regardless of
you
whether
don't.
it's a lease. Okay.
No, but a lease is constructed differently from when you own a legal interest in the land. When you own legal interest in the land and there are no debts against that land, that they say in law that you own that property fee simple absolute in possession. It gives you the right to quiet enjoyment to that land.
Hmm.
So you own,
Is-
so by right, you own the interest in that land.
Is there a percentage to that, or that's just verbiage?
If there is a what?
Is there a specific percentage attached to that? Or
Percentage?
Mhm.
What do you mean percentage?
So you say if it's an interest in the land, is it,
Right.
I don't know,
So,
50,
okay,
50?
all right. No. If I have a piece of land, 50 by 100, right?
Mm-hmm.
And I purchased that land from Mr. A. When I purchased that land from Mr. A, he had both legal and equitable interest in that land. He owed no one for that land. He now
Mhm.
sells that land to me. When he sells that land to me, then I own it 100%. I have both legal and equitable interest in that land.
But you don't really own it, right? It still belongs to the Crown, right?
Yes, you have an interest in it. So you have to pay taxes.
On taxes that can't be quantified. Like, I don't even understand how that makes sense.
What you mean?
I'm like, you can't quantify the interest in your possession.
Yes. If I take this piece of land now and I decide to sell it to you, you have 100% interest in this land.
But you don't,
Now,
because you don't own it.
no, you don't own the land. You own an interest in the land. And
But
your
if it's
interest could be
100%, doesn't that mean I own
100%.
it though?
No, your interest can be 100%. It can be 50%. It can be 75%.
Right. I guess I'm looking at it black and white, because if I'm in a partnership, right, and there's a 50% interest between two partners, like I understand that, okay, if I sell it, 50% of the earnings, I guess, belongs to me.
Yes.
But I don't see how that translates to something that you can't quantify your interest in a land that you don't own because it belongs to the Crowns. I mean, if you can't quantify it, you don't own it, you have no interest.
Yes, you do. Okay, do you have a piece of property now?
No,
You've never purchased a piece of property.
no.
Okay, so let's look in the newspaper. You see a house for sale,
Mm-hmm.
right? And you go and you just ask the person, how much is this house? Of course, it's the house and the land together. And he says, this house is going for 250,000. And you decided, okay, I have that because I have some funds that I have inherited. I'm going to buy this house. So you give him 250,000 plus whatever expenses that you have to pay.
Mhm.
When you get that document, that conveyance for that property, ABC on the corner of this and this, it will say that you have both legal and equitable interest in that land.
Mhm.
That's your piece of paper. You could then take that piece of paper and you could decide to sell that land to anybody.
But you'll be selling the interest, right?
You'll be selling the interest.
Right. I mean, and I guess they worded that way for a reason, because you don't own it, you're just selling the interest. It's not
You're
something
selling your
that you
interest,
own.
yes.
Right.
So that is why you see when the government wants to build a new road, what does it do? And houses are in the way. What does the government do? If they want to build a new road, what do they do when their house is in the way?
What do they do?
You have to pay the owners for the value or something? Don't they-
Yes, they do. Yes,
The
they pay
interest.
the owners for the value because they, by right, it is the land of the crown. So because you have built on the land, that has a value. So they give you the value for the land and then they just bulldoze it down.
So they give you the value of the home.
Yeah.
Basically.
Mhm. Yeah.
Right. I don't know if anyone else sees what I'm trying to say, but basically I'm saying you really don't own anything really. Because even the way the banks market their mortgages, they market it as home ownership. You own the home, but
Yeah,
like you say,
yeah,
you
you
don't
do have a,
technically
you
you don't
do
own the
have a
land
home.
though.
Yeah, but you do have a home ownership. It's
Right.
advertised as home ownership when you have completed paying your mortgage.
Right, but you own the home, which could
You
technically
don't
be
own the
blown
home until
away.
you finish paying for it
Right, afterwards. But you don't
afterwards.
specifically own the land or aka the property.
Yeah, you don't own that rock on that ground. You own an interest in that.
Isn't that, I mean, to me, that's like a tax on a tax. Like, why are you paying a rebuffy tax on the interest?
No,
I'm just
no, no,
getting
no,
deep.
no, no,
I'm
no,
getting deep. Don't mind me.
no,
You can
no,
you
no,
can go ahead.
no, no. But I mean, is it clearer to you?
No, I mean, I understand what's in my mind. I was
Okay,
trying to
what you
articulate
have
that.
to understand is like how you were using that analogy with a partnership, right?
Mm-hmm.
Okay, so partnership is partnership.
Mm-hmm.
Partnership has its own law.
All right, and it could be
Then-
quantified. I guess that's the part I'm
Then,
stuck on.
right, then you have companies that has its
Mhm.
own law. When it comes to land has its own law.
Mm-hmm.
So you can't take the terminology from one to the next one and mix them together. They
Yeah,
can't,
yes.
you can't marry them.
Can I say
The-
something?
Yes, go
sure.
ahead.
I mean, I understand what she's saying because I always related to the states. Because I know someone who couldn't pay the taxes on their home, and the state was able to, of course, it went in foreclosure, and they were able to sell it for the taxes. So I understand what she is saying, but we have ownership. How I look at it is we have ownership in terms that we have the right to sell it, and you could still get the value, which is your interest.
Mm.
I mean, that's how I look at it. But I
So
find
you're,
it when
okay, all right, but you're talking about couture, you're talking about when the bank decides that they want to foreclose.
no, I'm talking
You're talking
about
about just a write-out
a
sale. Yeah.
situation where the mortgage was paid, but you still have to pay the taxes. This is in the States now. I don't know how it works here, but that's only the reference that I know because I know of the situation. They weren't able to continue paying the taxes because even though they paid cash for the home, you still owe those taxes. And if you can't pay those taxes, your house can go into foreclosure by the state. I understand.
Mm-hmm.
Because you don't own that outright, the
Right.
state has a piece in that, you still owe those taxes. Therefore, the state was able to repossess their home and sell it
Foreclose,
for
right.
taxes if
Right,
they
right.
weren't able to come up and pay that. So that's why I think that's very weird. I paid for my house in cash, but that's why I didn't like the states. But it sounds like that's the same situation here. I don't know if
I'm
we
about to tell you that's what it is here. The taxes is your very first bill that you have to pay. Just like the United States.
Right, but what if I finish paying for this property? I finish paying my mortgage and everything, and
Mhm.
now I'm not in, of course, the real property tax still has to be paid, whether you finish paying for the home, the mortgage or no, right?
Right.
Mhm.
The house is still there, the house is
Uh-huh.
still on the land, you still owe the government.
And you have
So
to pay the
suppose I
government.
get into a situation where I cannot pay these taxes, that means the government now has the right to take my home
Yeah,
for
put it
their
up for sale.
interest,
Yes.
not
But
mine.
exactly, that's their interest. That's my
So I
point.
understand what she is saying. It's kind of
But
screwed
no,
up,
but
but
no.
okay.
Hold on.
I have a
What you mean? Hold on. What you mean by their interest?
I mean, because like she said, I don't really own this. So either I sell this to, either way, the
But you
government have to
okay?
get their
So
money.
but hold on. Your house is sitting on land.
On land what I thought I purchased.
No, you purchase an
Exactly.
interest in that land. You purchase an interest in that land.
Well, that's the screwed
I
up
guess
part.
the interest is the
That's what
tax,
she's
then,
saying.
Katura. I
Yeah,
guess that's what it is.
Okay,
I understand
let me
what
see.
you're
Let me
saying.
see. Let me see if I could try to recall this and see if I could do it simple. You have
No,
to
we
go
understand. We
you have
just
to
know
go
that it's
way
messed
back
up.
in time. Way
It's
back in
messed up.
time when people used to be farming. Way back in time. When it's be riding horses and fighting wars. So you're on your land and you're farming. Someone from the king comes for you to pay for the use of that land. That was different from the tax you had to pay after you sell your crops from the land. And that hasn't changed to today. You have to pay the crown.
Understood.
Yep, same, understood.
Yeah, you just have to pay.
So I have a question.
Go ahead.
As it relates to Katura's example, what is the likelihood of that happening in the Bahamas? Because I mean, I've heard that is an issue collecting real property tax. So unless the person is selling the property, how can that even be considered?
You mean you haven't paid your taxes?
Correct. I mean, yeah. So because I have some of my clients who are looking at purchasing property and they find out that this property has back taxes and they have to assume that responsibility to pay it. So there isn't any medium in place to actually go after those persons who aren't paying.
I think that is what they're trying to do, but tied up in everything because we are so small. Everything is tied to politics.
Okay.
And the cycle for politics is very short, 5 years. So even though they aggressively now, you see the banks are advertising in the paper that you have to pay your real property tax. If you haven't paid it, they're going to pay it and put a lien against your mortgage. So that means that at the end, when you think your mortgage is finished in 2026, you find out your mortgage is not finished until 2030 and you stop work in 2027. What do you see? What do you see looking out the window? Your house may go up for sale.
Right.
But
right.
is this something that they would just do, or this is something that they would have to notify you?
No. The law has been out long enough. The government has put enough notices in the newspaper. It is on their website. You are told you have to pay. They actually put in the newspaper when was the period when they were doing the assessments. They told you in the paper when the assessments were finished. They told you if you did not receive your bill in your post, come to the Department of Inland Revenue, get your assessment. You were told many, many times. So the government is not going to take any excuse that you didn't see it, you didn't read it, you didn't know.
So what you have to do, go and get your place appraised?
No, the government assesses it themselves.
Oh,
Yeah, that's a whole nother
They've either
story.
physically walked around or they've sent drones. So you go to
Is
the
it-
Department of Inland Revenue and you ask for your assessment.
so there's just something, okay. I have to look, I have to look into that.
Yes, you may owe the
Wait.
Bahamas government.
When you look, I have leads.
Ah, there you go. Shanika, you was going to say something? No way.
I was about to say, I guess to avoid paying the fees, just purchase a house under the value of 250,000.
Ah, there you go. You're getting right.
Or-
But you know
or
how
get
you
something
all
on
go.
Palmy Island.
Ain't no,
Yeah,
but you
that's
know
what
how
I was
you all
gonna
go.
say.
Y'all want something big.
That's what I was gonna say, that's all.
So tell me something, does it go by what
Pay
the
or
value
what's the
was
market
at the
value?
time
Yeah.
you purchase, or what they value it to be now?
What they value it to be now. There are
What they
plenty
value
people
it to be
making.
now.
Yeah, they're
So
whole
don't
big.
matter if you purchase, so don't matter if you purchase below 250, suppose you
No,
purchase.
no. If
years
you
ago.
purchase a house for 250, let's say you purchase a house for 250,
Uh-huh,
someone give you a good deal,
right?
but that's not the value of the house, and you know that.
No, what I'm saying is, no,
That's
I'm
what
not
I'm
talking,
saying.
you talk about the market
You
price.
can, you
I know what I'm saying. I'm
Okay,
saying,
go ahead.
suppose at the time I purchased, the value was under 250,000. They do
Okay.
this, the value, the appraisal value. I'm not talking about the price.
Mhm.
Suppose now they do this assessment and they value it to be more than 250. That's what you're paying on?
That's right, ma'am.
Have you not
Okay.
heard people making a fuss for the 2022 assessments? It's ridiculous. The spike is ridiculous. They need to clarify how was that calculated?
You got to go to Department of Inland Revenue and then
For them to
look at
tell
what
me
they have
voodoo?
assessed. Don't
Mm,
forget
yeah.
now, it's not just your home. It is also the homes that
On the
surround
land you
you.
don't, on the land you
Yes.
don't own, that they own.
But
I
we
mean,
have
facetious.
interest, girl. We have interest.
Right,
Don't
sorry,
worry.
the interest that they own, that you claim to tell people that you have, they're gonna charge you real property tax on that and increase it every year because why? Inflation and whatnot. Okay, I understand.
But don't forget now, each year, the value of homes go up, even if it's going up by $5,000 or $10,000. Look at the prices when you look in the newspaper. How much you see homes cost? 1.5 million, 2.8 million. I mean, your
Mhm.
figure may never get there, but it will be going up gradually.
Right.
In order for the government to sustain itself and pay its bills, it has to tax the citizenry. So
I
Mhm.
understand, but my problem with this government is it seemed like the pressures go on the poor man. And if we was collecting those taxes on them, these places, Old Fort Bay, Charlottesville, and Life Key, we'd be straight. That's all my problem is, do it straight across the board. But like you said, it's a small country and politics play a serious role and money talks. That's all I'm saying.
okay, all right. I hear you. But if we were to tax them, what will happen?
What you mean, what would happen?
Yeah, if you tell them now, all those living out west and all of those private gated communities who purchased their condominiums for 5 million, 6 million, 4 million.
They
What do you
probably would
think will
limit their
happen?
investments in the Bahamas.
That's what
Right.
they will do.
So that's that. So you don't worry about us who purchased at So you saying the amount of money, you don't worry, but us who purchased a 200,000 and gone up and now you want tax us. So we feeling sorry for that. They could go, let them go.
And how are you gonna run this economy?
But my thing is, if you're gonna give them exemption, I mean, you don't care about the small man. You weren't, but these people popping up and going, yes, you could give them concessions, you know, but they have to pay something. We all
Who
know
says
that.
they're not paying?
Why, listen to me, listen, you.
Well, if they are paying and then we shouldn't have an issue collecting from them then. So why would they leave if they're paying?
But if this
What
is
do-
America,
Why
they have
do
to
they come
pay.
here? That's the first thing. Why do they come here?
We're not a tax haven anymore. That whole illusion of a tax haven has been gone. When we implemented VAT, that tax haven thing gone, long gone. And that was the initial thing. They know why they come here, because in America, they run it from taxes and then don't want to pay none here. That's why they run it. But you know what? These things is getting me hot.
But you see, we try to shine a light on it by saying when someone comes to build a community, we talk about jobs, construction. How many people getting construction job? Then when they come in, of course, they would get a condominium or something, but they're gonna build a small hotel somewhere. And so that's more jobs for you, be it housekeeper, maid, boatman, or whatever it is. But that's the praises that is sung.
Listen, I have had guests sit down, this guy, sit down at my table and bragging about how the government basically giving away stuff. And you know what he said? All I do is tell them I'd give them some jobs. Huh? Why not empower your Bahamian people? I know a group of Bahamians that wanted to do a project. You know the red tape the government give them, but when they partnered with foreigners, oh, everything approved, concessions, that it is better in the Bahamas, but not for Bahamians. But I don't want to have this. I done. I'm mute now.
But think about it. You see what you just said just now, right? Bahamians went through a lot of red tape. The other ones brag about what concessions. Don't you see the picture?
Yeah, better
No.
for foreigners. Once you come in here and say you as a foreigner, the government, oh, and I control, and what they do is they throw jobs in front of you. Empower your
But they
Bahamian
throw
people.
more than jobs. Think about it. It's more than just jobs they throw at them.
That's the first thing these foreigners to say. Oh, I'm telling you, I speak firsthand with these people. I work in the casino. These people come in the casino and they talk. They talk amongst themselves, and you hear the foolishness that the government has been doing.
Mm-hmm.
I hear it every day, all day, and they bragging. All I do is
But they don't tell you the other part though.
Do you mean the under the table part?
Ah, there you go. We say nothing
Okay.
else.
No, nothing
there
else.
You go. So
we could wrap that session right there.
Yeah,
right.
we
So right. So you want to start your business and you saying you can't get anywhere. What are you offering? We end that there. Everybody going quiet.
Drop the mic.
Oh. All right. So y'all go back cool then. So from on the real estate side, the vendor and the purchaser each pay half of the stamp duty. That's in a normal, typical transaction. The VAT is payable on a conveyance, must be paid to the VAT controller, and thereafter taken to, now is the Department of Inland Revenue. If the VAT controller is not satisfied with the consideration amount, one must produce the appraisal report, and that contains the true market value, and that's normally done when stamping documents at the public treasury. The commission on the sale of developed property is 6% of the gross sales price, And the commission on sale of underdeveloped property is 10%. And of course, VAT is added to the fee. So 1/2 of the government stamp tax. This is a graduated tax. The total amount of the taxes up to 20,000, the rate is 4%. Value greater than 20,000 is less or equal to 50,000 is 6%. 50,000 is less than or equal to 100,000 is 8%. And anything greater than 100,001 is 10%. The vendor legal fees is VAT of 10% is added to that fee. The legal fees on the conveyance of property are usually 2.5% of the first 500,000, 2% of the next 500,000, 1% of the next 4 million, and 0.5% thereafter. So the government stamp tax of 5% is also paid. The purchaser will be responsible for 1/2 of the government stamp tax and the purchaser's legal fees. The recording fees on the conveyance and the other closing documents which need to be recorded. And of course, the payment of the permit under the International Persons Landholding Act. So think about when a foreigner comes to invest in the Bahamas. First, he has to go through the Bahamas Investment Authority. He has to prove that he has substantial wealth. Of course, he needs the services of a real estate agent. He also needs the services of an attorney. He has to prove to the government that he is able to first purchase the property, that he is able to sustain whatever it is that he's promising he's going to build. And he also have to be able to show that the environmental impact on that property will not be damaging. And I'm sure you'd have seen with the passage of the legislation, different projects where they have sent the link for you to look, any citizen of the Bahamas to look at the environmental impact assessment that they would have done. So the purchase of real property is one of the most important investments that a person will make in their lifetime. The general principles of purchasing property is under the Conveyancing and Law of Property Act, and depending upon the type of property and the nature of the purchase. There are other pieces of legislation that govern the sale and purchase of property in the Bahamas. So the sale and purchase of property is initiated by a contract or an agreement for sale between the vendor and the purchaser. The agreement for sale outlines the terms and conditions of the sale of the property. That includes, but is not limited to, the purchase price, the deposit amount, the completion date. This normally 1 to 3 months from the date of the agreement of sale, the obligation of the vendor to prove good and marketable title, the undertakings by the attorneys for both the vendor and the purchaser, and the consequences to the vendor for failure to prove good title, or to the purchaser for failure to obtain financing, or to complete the transaction within a specified time period. The deposit is usually 10% of the total purchase price and is often paid to the vendor's attorney at the date of the execution of the agreement for sale. And those funds are held in escrow, pending the completion of the transaction. After execution of the agreement, the sale and the receipt of original and or copies of the vendor's title documents, the purchaser's attorney investigates the title to the property, and they do this by conducting a title search. They also will look at the Supreme Court cause list to see if there's any judgment against the previous owners, and also the person who's actually selling the property now. So under the Act, a purchase of land is not entitled to require title to be deduced for a period of more than 30 years, or for a period extending further back than a grant or lease by the Crown, or a certificate of title granted by the court in accordance with the Quieting of Titles Act, whichever period may be shorter. The purchaser's attorney may raise requisitions and ask questions or inquiries with the vendor or to the vendor's attorney after investigating title to the property. And as of course, and some of those questions have to do sometimes with looking at defaults. It should be noted that the agreement for sale normally provides for a specified time period, and normally that's 14 days from receipt of the title documents for requisitions on title to be made by the purchaser's attorney after investigating title. In addition to certain requisitions on title itself, the purchaser's attorney may raise questions on the requisite government and subdivision approvals, outstanding real property tax assessments and utilities, the survey of the property, and any pertinent easements, rights of way, and or restrictive covenants. Upon the requisitions on title being satisfactory, so satisfactorily answered, the purchaser's attorney will prepare a report or opinion on title for the purchaser and or relevant lending institution. The draft conveyance is normally prepared by the vendor's attorney and may also be reviewed at the time of reviewing and requisitioning the title and causeless searches by the purchaser's attorney. The conveyance will include the name and addresses of the parties, any pertinent references to earlier title documents, a detailed description of the property, any restrictive covenants, any rights of way, a plan of the property, appropriate affidavits of citizenship and witness, any other information that's applicable to the actual conveyance. Once appropriately amended and approved, the conveyance is finalized by the vendor's attorney and executed by the vendor and purchaser whose signatures are witnessed. A completion statement is prepared by the vendor's attorney and the balance of the purchase price is paid by the purchaser or the purchaser's attorney. Less, of course, the vendor's portion of stamp duty and any apportionment for rates and real property assessments and utilities. The legal fees may range from 1.5% to 2.5%, and they're paid on or before the completion by the vendor and purchaser to the individual attorneys. Commissions to real estate agents are also paid at this time. Requests are made to utility companies to return deposits to the vendor, and all utilities and real property tax assessments are placed in the purchaser's name. The conveyance is sent for stamping at the public treasury, and the stamp duty is paid on a conveyance, which is normally split between the vendor and the purchaser. And that is based upon the total consideration or purchase price of the property. After stamping, the title document is sent for recording at the Registry of Deeds and Documents for a nominal recording fee. The sale and purchase of real property is a valuable commercial experience for all parties involved. And with the appropriate knowledge and understanding of the conveyancing process, the vendor and purchaser can effectively and efficiently transfer title to property with more ease, flexibility, and skill. Any comments or questions?
I have a question.
Go ahead.
Let's say I purchase a property and I go through the bank to obtain the mortgage, and the attorney didn't do their due diligence, and they deemed the property to be, the title to be good and marketable. And let's say 5 years later, someone sues me saying that they have an interest in the property. Who then is liable?
Then you have to countersue the attorney.
Okay. So it would be the attorney who's liable, not the bank, not me. Well, I still have to sue the attorney, you're saying?
Yes.
Okay.
That's if he is still alive.
So what happens to then the first amount legal mortgage and the bank's interest and my interest? What happens then if the person comes back and says, hey, this is my property?
Well, you
What
would have
happens
already
to my
taken,
interest?
you would have already taken the bank's monies. You've taken the funds. They've had incidents like that in the Bahamas in the last, maybe say 15 years, when a lot of mortgages were done where the title searches were not good. They didn't have good title. And of course, the banks then proceeded to sue the attorneys. But the mortgages had to stay on the book. You had to pay.
And what happens to the property or the house?
Well, then that matter goes to the court, because then you have to find out who's the rightful owner.
Okay.
Yeah.
But all while this is happening, I still have to pay.
Yes, ma'am.
Okay.
Because you have an interest.
No, it's because you have a loan.
That was funny.
You all are just too funny. So as I said, when I started this section, when you're purchasing land, you have to get to what we call a good root title. That is what the lawyer is seeking, to get a good root title. And by law, he has a certain demarcation. So there's no shortcuts when you're trying to get to a good and marketable title. So he can trace a property back for 30 years to see who the owners were. A sold to B, B sold to C, C sold to D, D sold to E. He could go back to 30 years. Once he hits 30 years, he stops there. So no one could come after 30 years and say, guess what? Oh, my family owned this property 60 years ago. It goes back to 30 years. Or he can go back to the time when the land itself was quieted. And quieting means that someone would have seen a vacant land. They would have occupied that vacant land, planting on it. And then they would have fenced it in. Then they would have applied to the court to quiet that land. An ad is placed in the papers. You'll see the title say, under the Quieting Titles Act. They would give you the description of the property, tell you where the property is, and they'll tell you that this person is seeking to quiet this piece of land. They have no claims are brought before the court. Then the person is given that land. The land is conveyed to them by quieting. It used to be 20 years, is now down to 12.
You mean after they have occupied the land for 12 years, they can apply for ownership via the
Yes.
quieting? Okay.
Without, this is 12 years without someone coming to tell them that they have an interest in the land.
Correct.
Okay. So I guess to go back to Ernst's example, if that person who came to say, okay, no, my family owns it, if it was beyond 30 years ago, they would have no legal interest.
No, that's
there?
different. No, that's different.
Okay.
The quieting title is the one when time stops. Every time that person comes and says, this is my land, I ask you to move. Time stop. So they're on your vacant land and they're planting peas and corn, and you came today and you said, why are you on my land? I asked you not to come on my land. This is my land. You need to move. You record your date. So he cannot go to court 10 years from now and say, I have been on that land for 10 years, because time stopped when you advise him that that was not his land. Time begins again the next day. It goes back to day one. But you have to be reading the newspaper every day, because those notices come in the paper every day. The people are quieting land. So you mentioned mortgages. So a mortgage is an interest in property and is created by a form of security for a loan or payment of a debt. And it terminates on the payment of the loan or the debt. The borrower who offers and grants the mortgage over the property is called the mortgagor, and the lender is called the mortgagee. So the bank has three types of security: a legal mortgage, and that confers a legal interest on the mortgage, on the mortgagee, and may only be granted by the mortgagor who has a legal interest in the land. You understand that? Yes?
Yes.
Okay. The other type of security is where you have an equitable mortgage, and that confers an equitable interest on the mortgagee and may also be granted the mortgagor who has a legal interest. But if he has only an equitable interest, then he may only grant an equitable mortgage of his interest. And third is an equitable charge, and that confers an equitable interest on the chargee, but with more limited rights than an equitable mortgage. So the first two types of security are typically used by mortgagees, particularly financial lending institutions, because they provide more attractive rights and remedies to mortgagees. So a mortgage document specifically describes the parties to the transaction, the terms and conditions upon which a mortgage is granted under the property by the mortgagor, and upon which the loan is given to the mortgagor by the mortgagee. That is prepared by an attorney and is usually executed by the mortgagor after the appropriate title and Supreme Court costless searches are made. Real property taxes, utilities, and other rates and assessments are verified, and title to the property is proven to be that of the mortgagor and found to be both free and clear. The mortgage document typically includes, but is not limited to, terms and conditions, which outline the obligations of the mortgagor to repay to the mortgagee on demand the principal, interest, and any costs relating to the mortgage loan, to keep the property properly insured and maintained, to regularly pay all rates, taxes, and assessments, observe all restrictive covenants and regulations, and protect title to the property. The mortgage document also provides a detailed description of the property, the duration of the loan, the amount of the monthly payments, the date of payment, the mortgagor's redemption of the mortgage upon repayment of the loan, and the events of default upon which the loan may terminate and upon which a mortgagee may exercise its legal remedy, which can be a foreclosure, a power of sale, a right to possession. An opinion on title confirming or attesting to the validity of the title to the property is issued by an attorney to the mortgagee, who is often a licensed financial lending institution. So upon completion of the mortgage transaction and before approval is granted for the loan to the mortgagor, it is important that the mortgagee satisfies himself that it is legally in a position to grant the loan. And particular attention is given to the fact that it is not adversely affected by the rights of persons, especially in light of the provisions of the Inheritance Act regarding the right of spouses and other pertinent statutory and common law principles that relate to or may affect the legal interest in the property over which the mortgage is being granted. The stamp duty on a mortgage loan is normally 1% of the amount of the mortgage advanced to the mortgagor. So all that is saying is that when you apply for a mortgage and the bank is actually having the title search, they have to take into consideration not not just that you have both legal and equitable interests, or you just have an equitable interest because you are a beneficiary of a trust, but they also have to look at if there are any adverse rights to those property. Because sometimes the property is owned by more than one person. Sometimes the property may have been conveyed without taking into consideration the rights of other persons who may be entitled to a portion of that land. So the mortgagee protects its security rights over the mortgage property against third parties, such as subsequent mortgagees or purchasers of the mortgage property, by recording and registering in security over the property by having the mortgage document stamped and lodged for recording. It should also be noted that the mortgagee often takes possession of the original title documents, including the original mortgage, after recording at the Registry of Deeds and Documents. Mortgages rank in order of priority. That is, according to the date of recording of the mortgage document. And according to Bahamian law, the first mortgagee in time takes priority over subsequent mortgages. While the mortgagor has paid off the loan and the property become free of the mortgage granted over it, the mortgagor has effectively redeemed his property. So during the currency of the mortgage, the mortgagor has residual rights in the property known as the equity of redemption. And the equity of redemption is the right of a mortgagor over his mortgage property, particularly the right to redeem the property at any time on payment of the principal, interest, and the cost of the mortgage loan. The value of the equity of redemption is the value of the mortgagor's unencumbered interest minus the value of the mortgage loan. The law governing mortgages in the Bahamas have ensured that the mortgagor is protected from any undue advantage by the mortgagee by ensuring that if a transaction is in essence a loan on security, it is treated as a mortgage, notwithstanding the words of the mortgage contract, and by ensuring that there are no clogs or fetters on the equity of redemption in the mortgage document, which may unduly prejudice the mortgagor. And similarly, the courts are being cooperative in assisting mortgagees in exercising their legal rights and remedies against defaulting mortgagors. And one of those could be the recently passed Homeowners Protection Act. Any comments? No? Okay. So when you talk about, so we've looked at our legal system. We looked at persons who would come to the Bahamas to invest in the Bahamas and the different statuses that they may have. We've also looked at the different ways in which you can start a business, sole proprietorship, partnership, or a company. We have also looked at when you wish to purchase property and obtain an interest in land. You also talk about when you don't have the funds to pay for that land and you go to the bank for a mortgage. Now, on the other side of that, a lot of people want to invest. And you can have investments and you can also have what we call estate planning. And estate planning includes investments. So one of the ways in which persons, especially foreigners, when they come to the Bahamas and foreigners from overseas, what they do when they want to do estate planning is they set up a trust. And to set up a trust, they would normally go to a licensed trust company. So to establish a trust, there are legislation that deal with trust business. You have the Trustee Act, the Trust Choice of Governing Law Act, you have the Perpetuities Act, the Rule Against Perpetuities Abolition Act, and you have the Fraudulent Disposition Act. And that doesn't include, when you look at someone who's doing estate planning, there are other pieces of legislation when they set up their structure. Because they set up their structure for estate planning. Some of them do it also to minimize taxation. So the establishment of a trust for the distribution of assets, the named beneficiary or class of beneficiaries during a person's lifetime or upon his death. So some people set up a trust for estate planning to be able to distribute to their children or their brothers and sisters or their parents. Sometimes they include themselves as a beneficiary. Or sometimes they'll say to my grandchildren or to my children or to my great-grandchildren. That's called a class. They can pay these persons while they are living, or the trust can be set up that they are paid or given dividends out of the trust upon that person's death. So a trust is really a legal binding arrangement in which a person, known as the trustee, they hold, they manage, they administer the assets that were originally owned by the person who transferred it to them. So the person who transfers the assets is called the settlor. The person who manages and holds and administers those assets is called the trustee. And they do all of this for the beneficiaries. So both real and personal property can comprise the assets of a trust. Once the settlor transfers the assets to the trustee becomes the legal owner of those assets. The beneficiaries become the equitable owners of those assets. So the beneficiaries can receive payments from the trust for the duration of the trust itself. They could receive payments on special occasions or on requests. Or there are some trusts that are set up whereby a beneficiary only receives a payment at the discretion of the trustee. There are some trusts that are structured whereby the beneficiaries can receive capital from the trust. It should be noted that only beneficiaries of a trust can enforce the provisions of a trust. Only the beneficiaries of a trust can bring a legal action against the trustees of the trust. A settlor can only enforce the provisions of the trust or seek legal action against a trustee if he is a beneficiary of the trust. So there are different types of trusts. There are discretionary trusts, there are non-discretionary trusts, there are fixed interest trusts. You have part discretionary, part fixed interest. You have revocable trusts, you have irrevocable trusts. A discretionary trust is where the trustee makes all of the decision as to when distributions are made and how much. A non-discretionary fixed income trust is a trust where the beneficiaries are entitled to a fixed share of the assets of the trust, and the right to such entitlement may be enforced by the beneficiaries of that trust. A part discretionary, part fixed trust is a trust where the trustee acts on behalf of and for the benefit of a certain class of beneficiaries during their lifetime, and then they exercise their discretion in favor of another class. A revocable trust can be revoked at any time or canceled by the settlor. He can do it in whole or he could do it in part. And this requires a trustee to reconvey or transfer the ownership of the assets of the trust to the settlor. An irrevocable trust cannot be revoked and it cannot be canceled by the settlor. So there are some advantages to setting up a trust. A trust doesn't have to be probated. And we're going to do a will in the next class. A will has to be probated. A trust is a confidential document and is not required to be filed publicly. A trust affords a person planning his estate the expertise of a corporate trustee where necessary or applicable. A trust affords certain insurance options. A trust avoids delays in beneficiaries receiving assets because the distribution of payments is done continuously depending on the type of trust, versus if there is a will and there is a probate, or if there is no will and there is administration of the estate, there is a time period that you have to wait. A trust may be used to protect assets from creditors. So you know if a person dies with a will or without a will, persons can bring claims against the estate. Yes, Danica?
Sorry.
Oh, I thought you had a question. So a trust in the past used to be perceived as something that only the wealthy would do, but now a lot of people are turning to establishing trusts. So a trust is an easy and affordable way today due to growing numbers of financial institutions who offer such products. And legal practitioners who provide sound legal advice, direction, and assistance in the creation of such trusts. They're used as a standpoint of prudent estate and financial planning. And in some instances, they're considered the vehicle of choice. So a trust can be established in the Bahamas and you could transfer it to another jurisdiction as long as the laws are comparable to the jurisdiction where it's coming from. So most trusts have what we call a proper law that governs the terms of the trust. And normally they try to make sure that and the assets are closely connected. A settlor could choose to have his trust administered by trustees in a jurisdiction different from that of the law of the trust. But it's always advisable that he chooses the proper law of the trust based on where the trustees are resident, since the courts of the proper law jurisdiction would be more inclined to afford protection to both the local trustees should there be a dispute. A settlor can avoid obvious management, control, and taxation problems by appointing trustees who are resident in the proper law jurisdiction. In most trust deeds, there will usually be some provision that cover the power to change the proper law of the trust to that of another jurisdiction. And that power will often be given to the trustees of the trust, and a deed or declaration is executed by the trustees to effectuate the change of the proper law. The most common method of transferring a trust to another jurisdiction is by having the existing trustees appoint new trustees in the chosen jurisdiction, and then they would retire the trust in a deed of retirement and appointment. And then on retirement, the existing trustees and the appointment of new trustees, and then the assets will be transferred to the new trustees or will automatically vest in them. And then, like I said before, when you transfer a trust to another jurisdiction, it must have similar laws to the jurisdiction from which it's being transferred to. So normally you look for the similarities or the differences in the trust laws of both jurisdictions. You look at the interests of the beneficiaries and whether the change of jurisdiction or the change of trustees, You look at the interpretation of certain words compared with other jurisdiction, and you also look at the appointment of trustees in the new proper law of the jurisdiction. Most trusts will have a flee clause, and that's normally will contain some provision that in the event there is some occurrence, you'll be able to transfer the trust to another jurisdiction. And that's why the Bahamas boasts of having a stable political landscape, so that persons, trustees, and the beneficiary don't have that fear that they will suddenly have to flee. New trustees who are appointed under deed of retirement and appointment should, as a matter of good practice, review the trust law of the original former jurisdiction to ensure that they are comparable to those of the country in which they are resident. The new trustee should also investigate the existing relationship between the original trustee and the beneficiaries and any administrator and accounting issues that may pose potential conflicts. So a trust, like I said, there are different types of trusts. And one type of trust is what we call an express trust. And this is one that is created intentionally by the express declaration of the settlor. And he could do that by deed, he can do it by will, or any other form of writing to give benefit to individuals or a class of individuals. An express trust can be private or it can be public. A protective or discretionary trust may also be included in the phrase. So if a settlor intends that a trust or property shall arise upon his death, this creation of trust must be by will or by a codicil. So to be valid, a will shall be made by a person who is at least 18 years or over. He's of sound disposing mind, and it has to be in writing, signed by the testator or any other person in his presence. The signature is made or acknowledged by the testator in the presence of 2 or more witnesses, and each witness either attests and signs the will or acknowledges his signature in the presence of the testator. So for a will to be valid, there are 3 things that must be present: certainty of words, certainty of subject matter, and certainty of objects. And words means the particular words such as trust or confidence doesn't have to be used for the creation of a trust. There's no precise language. Everything is based on what was the intention of the person at the time that the trust was created. Certainty of subject matter, it means that the property which the settlor owns must be certain. And certainty of object means that the settlor must know who the beneficiaries are. So if the words are uncertain, the donee or the gift goes back to the property beneficially. If the subject matter is uncertain, the transaction fails in its entirety. And if the object is uncertain, if the words are sufficiently certain to have created a trust, but the objects are uncertain, then what we call a resulting trust will arise, which means it goes back to the settlor, or it was done by will, it goes back to the estate. Any comments, questions? None? The next section I have here is on investment funds, but we won't go through that because when we go further down in some of the other areas, we will talk about investment funds. More in particular of the products that the Bahamas offers. But the last topic for tonight is the hot topic. I know you've seen it a lot in social media. You would have seen it also in the newspapers, on the television, and that's the Bahamas' new product that is offering, where everybody is coming to the Bahamas to obtain a license under the DARE Act, the Digital Assets and Registered Exchanges Act, 2020. And this legislation was promulgated to attract persons who want to enter the digital asset space. It's a new financial industry, and it shows how compliant and well-regulated the Securities Commission has created this piece of legislation to attract businesses who want to do business in that digital space. It also attracts existing and entrepreneurs, and it gives them an opportunity and gives also the Bahamas an opportunity to participate in the fintech industry by licensing these operators. And hopefully that they will work with firms in the Bahamas, and that Bahamians, of course, will gather the skills to work in the fintech industry. So the legislation facilitates the registration of digital token exchanges, the provision of services related to digital token exchanges. It also provides for the regulation of digital assets-based payment service businesses, and for the registration of financial services related to the creation and issuance or sale of digital tokens and other digital assets. The legislation also sets out the requirements as to who participates, the level of capital required, the rules for reporting and seeking the Securities Commission's approval, and the penalties for failure to comply. As a participant, registrants must comply, of course, with our anti-money laundering and our counterterrorism financing laws. And of course, the Commission is currently in the process of drafting and seeking comments on its money laundering laws related to digital assets. And the Bahamas has also, at the same time, modernized its legislative framework with the financial corporate service providers. And that's so that it now includes the provision of custody of digital assets and wallet services providers. In line with this, of course, is the central bank's promotion of its sand dollar. We were the very first country to produce a digital coin. And like cash, the sand dollar, of course, is issued through the central bank, by the central bank through its authorized institution. Any comments? No?
No, you can just repeat what the AML and CTF stand for, please.
Anti-money laundering, counterterrorism financing.
Thank you.
Okay. So if there are no more comments, next week we're going to talk about writing a will. That's why I went over that section rather quickly when I spoke about a trust and how you can create a trust within a will. But next class, we'll actually talk about a will itself. How do you write a will? What makes a will valid? So we'll do that in the next class. Okay? No more questions? Yes? No?
No, ma'am.
All right. So I bid you good night. Read up on wills and probate, and we'll have a discussion next class.
Okay, thank you. Good night.
Okay, good night. It'll be on a Thursday now. Back to Thursday.
Okay.
Okay,
Good
all right.
night.
Good night.